Hello everyone, I'm intern working LEXIS and Company and I'm going to present on the topic the military law of India and its loopholes. So the military, our Indian military has been ranked 5th in the world and for the purpose of providing justice related to the military crimes, there has been established a different court system for the military, and it is even the higher judiciary doesn't have any binding upon the military court decisions. So the need of so the military codes came into existence from the British Raj, and it still prevails. The need for a separate system is that our higher judiciary has our normal judiciary set up in India has lots of cases registered, and our military cannot wait for delayed trials. So, for the purpose of speedy trials and predictable decisions, in order to maintain the uniformity of the military, there was establishment of the separate system. Certain offences like desertion, insubordination, or absence without leave are kind of common military offences dealt. So, the Indian military justice system was opinioned in the Constitution in the Article 33, which states that the fundamental rights and duties would not be would can be restricted upon in the cases of military personnel in order to let them perform their duties in an effective manner. Also, the Article 136 and 224, 227 restricts higher judiciary's right to interfere with the orders of the court martials. There are four court martials. First is the General Court Martial, Summary Court Martial, uh, then there's District Court Martial and Summary General Court Martial. So, in accordance of the Army Act, there the personnel can be tried for all kind of offences in military except the murder and rape of a civilian, and the murder and rape thing can be tried in the civilian court of law. So there are five acts which tells about how the military offences can be regulated. There's Army Act of 1950, Army Rules of 1954, Navy Act, Air Force Act, and Armed Force Tribunals Act. So the military crimes are committed crimes in that are specially mentioned in the acts which I mentioned earlier, and for the purpose there is an investigation process in the military law, which is varied depending upon the issue. Then there are elements in the military codes, which is the prepared defense, uh, counsel for the accused, all information which is conveyed freely, speedy trials, which is the most important thing. The trials are concluded within a reasonable duration, independent and impartial trial, right to inspect proceedings in open trial. So the punishment for the military officials are termination of employment, uh, forfeiture of the pension and other possible benefits, limiting the benefits in the pension fund, or complete loss of designation. So there are many deficiencies in this form of justice system, which is the most important thing which I'm going to discuss right now. Then first is bail. There is no provision of bail for an arrested military person within the provisions of the Act. So officer charge is essentially he is the one who will decide the case. Second is trial and summary court martial. So in trial and summary court-martial, there is no prosecution given to the accused, which is against the Article 22 of the Constitution. There is violation to Article 21 as well. Article 22 deals with the unwanted arrests and detentions, and Article 21 is the freedom to personal liberty. And also Article 14 of the Constitution, which is the equality related article. Then comes the legal aid to the accused. So even though there is a provision that the military officer which is accused would be provided with a counsel or a officer, but these service officers are mostly very inexperienced, non-committed to the accused. Furthermore, the accused have to pay for the proceedings, and if they aren't able to do so, there is no other option for them to be saved, and this violates the Article 39A of the Indian Constitution, which is right to free aid to ones that really requires it. Then members of the court-martial. Members of the court-martial are which are appointed are mostly lacking in experience, qualification, and training to fulfill the role. And also, critics state that there is a phenomenon called as command influence, which is their decision making is being influenced by the executive. So it is not independent or unbiased. Then comes the functioning of the Judge Advocate General Department. The Judge Advocate has no role to play. They neither function as an advocate or as a judge. As a comparison of Judge Advocate to the judge of other trials, the Judge Advocate is within the administrative and functional control to the executive, while other judges are often independent of the other departments of government. So there is also a loophole, the loophole called the double jeopardy, which is the trial of accused twice for the same crime, which is not acceptable. And Article 20, subsection 2 states that a person cannot be tried twice for a same crime. And if a person is tried in a court-martial, he cannot be stopped from the second trial for the same offense in the civil court. Then comes the loophole of denial of appeal, of right to appeal. In the Chapter 12 of the Army Act, from the sections of 153 to 165, there is in section 153 there is no finding or sentence of parties like general, district, summary. General, the decision that is constituted valid. Section 160, the revision of a finding or sentence of a court-martial through an order is confirming and a decision is passed. And section 164 of the Army Act deals that there can be a remedy available to those parties against whom the verdicts are given, but mostly it happens very confidentially and not and it is mostly a formality, and it is not done with the most required standards. So the provision is mostly unsuccessful, and it is done behind closed doors, and it is equal to no justice. Then the last is the Armed Forces Tribunals, which was established through an act of 2007. It is to revolutionize the military justice system of India. At present, it has failed because there is a shortage of the tribunals in India. So there is a lot of delay in the judicial process. Also, the implementation of the final orders aren't happening. If it happened, there would be a relief to a lot of litigants, because implementation is not happening because in most cases the union of government and the defense department is accused. That's why the implementation process is not happening. So thank you. This was it for the presentation.